Welcome back to Surviving Satchidananda. I'm your host, Brianna Patton. This episode examines a lawsuit that raises an important question. When a powerful spiritual leader is accused of abuse, what responsibility falls on the people who supported him and the institutions they helped create? In 2023, Shanti Norris and Susan Cohen, former devotees of Swami Satchidananda, filed civil litigation against Yogaville and Integral Yoga. They alleged that the organizations failed to protect them from sexual abuse by Swami Satchidananda. Because the guru is no longer alive, the case centered on the responsibility of the organizations and leaders who were present at the time and remain in positions of influence at Yogaville. We previously discussed this case in episode 4 with attorney Carol Murchison, who represented Shanti and Susan with her team at McAllister and Olivarius. When we recorded that episode, the litigation was ongoing, so Carol could not speak to the specifics of the Yogaville case. So instead, we focused on the broader legal process involved when holding spiritual organizations accountable, as well as common patterns among survivors of spiritual abuse across different religions and traditions. We also discussed how many survivors seek non-economic remedies, like consent training for leaders and institutional reforms, in addition to financial compensation. This lawsuit renewed attention to long-standing controversies surrounding Swami Satchidananda's relationships with his students and raised difficult questions like, what did Yogaville leadership know, when did they know it, and how should institutions respond when allegations of abuse surface? The case has now concluded with a confidential settlement and a joint public statement between Shanti Norris, Susan Cohen, Yogaville, and Integral Yoga. You can find that statement in the show notes, and we will return to discuss it at the end of this episode. While the settlement brings this legal case to a close, it does not end the broader conversation that we have been having on this show. To help unpack the legal significance of this case, I spoke with Professor Marci Hamilton, a leading expert on clergy sexual abuse and statutes of limitation. Professor Hamilton is the founder and CEO of Child USA, a nonprofit think tank focused on ending child abuse and neglect. She is a professor in the Department of Political Science at the University of Pennsylvania and has spent decades advocating for survivors, particularly through her work to eliminate statutes of limitation on child sex abuse. She is the author of Justice Denied: What America Must Do to Protect Its Children, and God versus the Gavel: Religion and the Rule of Law. She also served as an advisor to the Jeffrey Epstein Victims Compensation Program, where she worked directly with survivors and provided expertise on sexual abuse. In our conversation, Marci and I discuss why this lawsuit matters and what we can learn from it. We also talk about how statutes of limitation impact victims, and we unpack how horribly Yogaville treated Shanti and Susan throughout this entire process. Professor Hamilton had no prior involvement with this case and has no affiliation with Yogaville, so I'm very grateful that she took the time to review the details of this case and share her perspective and expertise with us. We all know how much lawyers can charge for their time, so I think the fact that both Carol Murchison and Marci Hamilton donated their time to educate us for free speaks a lot to their character and who they are as people. We recorded this interview before the settlement was reached, so Marci does not comment on the final agreement. However, she did predict that the case would likely resolve the way that it did. Here's my conversation with Professor Marci Hamilton. Professor Hamilton, thank you so much for joining us today and sharing your expertise with us.
Thanks for having me, Brianna.
Can you tell me a little bit about how clergy abuse became such a central focus in your work?
So I'm actually a constitutional law scholar and professor, and I was involved with a case at the Supreme Court that really educated me about religious groups breaking the law and became the leading expert on what do you do about religious groups that break the law. And when the clergy sex abuse crisis really broke publicly in 2002 with the Boston Globe Spotlight story, I became the law professor who was on the side of the victims. And then that turned into an interest in statute of limitations and also all other child sex abuse. But clergy sex abuse is really one of my primary areas of expertise.
And you mentioned statute of limitations. You advocate for some radical changes to statutes of limitations when it comes to cases of sexual violence. What are the changes that you are endorsing, and why are these changes necessary?
So I wrote Justice Denied, What America Must Do to Protect Its Children many years ago, I guess almost 20. But my argument is that we should just eliminate statutes of limitations for child sex abuse. For the victim, it's not terribly different from murder in the sense that it's very hard for the victim to come forward. It's very hard, as we learned through the science, the average age is about 50 to come forward. And so we need to get rid of the statutes of limitations because we need their stories, we need the truth, and that's the only way we can reform.
Yeah, I heard you in an interview talking about how in some places it's 2 years that a child has after the date of the assault for them to come forward. So I'm thankful that you're doing this work at such a high level. It's really important. And I've also heard that you've done a lot of work with the Epstein victims. Can you tell me a little bit about what that looked like?
Yeah, so I was really honored to be chosen as an outside consultant for the Epstein Compensation Fund, which was put together by the estate. So I had the honor of meeting with about 100 survivors of Epstein. These were very brave women with very different stories about how this terrible trafficking scheme found them and then exploited them according to their dreams, whether they wanted to be a model or they wanted to go to school. And it really changed my perspective on the way to understand these issues because this was a key example of coercive control, which in the old days, decades ago, someone might have called it brainwashing. And because we have developments in social science, psychological science, medical science, we now know coercive control really happens. And these women were stuck and taken advantage of. And it really was educational for me, but also an honor to be able to speak with them.
You mentioned brainwashing and coercive control. Are there laws that prevent these tactics from being used in the United States?
The laws aren't strong enough. And there's actually a piece in the National Law Review right now, which is really troubling, by Tony Farina, in which he says that you shouldn't be able to prosecute someone for coercive control, for taking control of their will and their capacities, because then you're going to destroy the First Amendment and you're going to undermine religious liberty. That's ridiculous. The science is that it is possible for especially religious leaders and very charismatic religious leaders to bring children and women and men into their psychological control and to lead them to do things that they never would have agreed to. So we need to strengthen our coercive control laws in every state. In some states, we need to introduce the concept, and we also need to educate the judges about the reality. It's just not true that people always have free will to just walk away from these really difficult situations.
Yeah, the more that I learn about coercive control, it's apparent just how widespread and textbook these methods are deployed. And the people who are doing this know exactly what they're doing. And when you add the spiritual layer, claiming that's violating the First Amendment, if we're not allowed to do that, I think that's ridiculous.
Well, it's typical of our religious bad actors in this country. They love to wrap themselves in the First Amendment. But the First Amendment was never designed as a refuge for scoundrels, for people who are just going to do bad things. So what they're trying to do is weaponize the First Amendment to harm the vulnerable. And I think we've reached a point where judges can see through it, but they need to see through it.
What are the crossovers that you see between clergy abuse cases and what you've seen in the Epstein cases?
Well, with both universes, and I would throw in Penn State, what these universes tell you is that powerful people protect each other and they look to each other's interests. And children and vulnerable young women in particular are so easy to devalue. Their well-being, their futures really don't matter so long as the powerful protect their institutions, their money, and their names. It runs across the clergy sex abuse cases. It runs across the Epstein trafficking scheme. And at Penn State, I mean, even Joe Paterno, the beloved, coach, toward the end of his life, he said, I really should have done more. And that's the whole project of the child sex abuse and statute of limitations movement, is to teach and to get people to understand we can't just let adults prefer and protect themselves.
Yeah, I notice a lot of the same things with this case with Yogaville, with Swami Satchidananda. The more I research him, as you and all the listeners know, there are tons of yoga gurus who came to America, and so many of them have been accused of sexual violence. They all hung out with each other and protected each other. So it's a huge network that layers right on with this Epstein thing that we're seeing play out.
I mean, it's really remarkable because the very first window, we call it, where we opened the statute of limitations, effectively was in California in 2003. And that window, for 1 year, California said, if the statute of limitations has expired, you can still go to court. Well, there were about, out of 1150, there were about 850 Catholic victims, but there was also explorers, scouts, and there were some other religions. But the day that closed, 2 days later, I was contacted by a victim of a yoga swami. And there were a whole line of victims behind this person. And it was so heartbreaking to have to say to them, the statute of limitations has already closed. We need to open it up again for people like you. But at that point, I had not yet heard about the problems in that system, but they're pretty severe.
Yeah, and I want to get into the weeds of this case we're currently looking at with Yogaville. Just to give a little bit of a recap, it's Shanti Norris and Susan Cohen were both teenagers when they became devotees of Swami Satchidananda. They're alleging that they were recruited into this organization, subjected to a system of coercive control, and this enabled repeated sexual abuse by Swami Satchidananda. And they're claiming that Yogaville committed workplace sexual discrimination, negligent supervision and retention, and gender-motivated violence. Is it common for cases of spiritual abuse to go this route and suing the organization as their employer?
Absolutely. This is the way that the child sex abuse cases against the Catholic Church, the Baptists, the Mormons, and so many others have gone. And those are the theories that have to be brought. Now, coercive control is something that has been used more in this context than in the Catholic context, but it certainly would apply.
What makes someone an employee in a religious or communal setting? Because Yogaville is saying that everyone was a volunteer, there are no employees. How is the court going to distinguish that between the religious and the employee setting?
Well, I mean, that's just a fact finding that the court or a jury is going to have to find. Did they receive payment? Did they do work? Were they labor for the organization in some way? Were taxes paid? I mean, there are a lot of indicia of employment, and those are the things that the court's going to have to look at.
From my understanding, there was no monetary compensation, but all their room, their board, all their travel expenses were paid for in exchange for this labor. Are volunteers protected under employee laws when it's a situation like this, when your housing is tied up in your work?
Well, I think I would translate the housing, the board, and the travel into compensation. They were receiving compensation for staying there. And so the fact that their basic living was being given to them, I mean, in some ways, this reminds me of Scientology, because Scientology, when it holds people, will provide, you'll get housing and you'll get food, but you make so little that it's as though you make nothing, and they still get forced labor out of them. So this to me sounds like it's not merely a volunteer relationship. It's a quid pro quo relationship. And so they should be legitimately subjected to the laws that apply to employees. So negligent supervision. But at the same time, the other theories, coercive control, negligence in the handling, even if they're volunteers, negligent handling of volunteers would also be legally capable of moving forward.
I imagine this would open up a huge can of worms for Yogaville because still their entire business structure is centered around volunteer labor. So depending how this case goes, that could open up a lot more for them. You mentioned quid pro quo sexual harassment, and this is something that Susan and Shanti Norris are both claiming. Can you explain what quid pro quo sexual harassment is?
Well, it's this concept that there is an exchange of value for sex and for sexual relations. And so what's happening here is that these are girls that need housing and board, and that are being taken around the country. And so the sex is part of the deal that's being cut, even if they don't have the kind of complete free will that they need in order to walk away from it. Harassment is, in this case, very, very closely overlapping with coercive control.
Was this something that came up in the Epstein cases as well? Because I'm just noticing like the whole massage thing. Swami Satchidananda trained a lot of young women to be his massage therapist, and then abuse happened. Is this quid pro quo claim something that happened in the Epstein case as well?
I haven't seen it. Most of those girls who are now women basically have sued for sexual assault and abuse as opposed to employment relations, although some of them clearly were forced to do labor. So in that way, I don't see exactly the same parallel. But what's going on in the Yogaville case is the plaintiffs have more theories, which is a good thing for the plaintiffs. And I hope that they're able to prove up this controlling relationship.
One of the claims we mentioned was negligent supervision and negligent retention. What does that usually require in a case like this? What type of evidence is necessary?
So essentially what the courts will ask is, did they know or should they have known that this man was dangerous to these vulnerable victims? And if they knew or should have known, they should have let him go. That's the retention side of it. And if they knew and didn't give him any guidance as to, you can't work with girls anymore, or you can't be one-on-one private with these girls anymore, that's negligent supervision.
When I first read this, I chuckled because the idea of Swami Satchidananda's devotees telling him no, trying to change his behavior at all, was just something that would never happen. And even in the case, they talk about you could not say no. So it's just crazy to me how these dynamics work where there's a spiritual element that's not congruent with American law.
Well, it happens a lot in the religious context. So in the Catholic context, there's a rule against scandal, and nobody's allowed to say anything negative about the church publicly, or there's a threat of being excommunicated. This is in a letter from 1964 from the Vatican. And so this whole obedience element is critically important to understanding the coercive control. And when it's religious, it holds the victim in place in a truly effective and devastating way.
Yeah, I hear a lot in relation to Yogaville. They say, oh, there is no coercion. This isn't a cult. You're free to leave at any time. But that just completely ignores all of the psychological research that we have about these methods and how you're kept there psychologically. You're not chained to any organization.
Yeah. I mean, what that means is, in the end, one of the most important elements of the case is who are the experts on each side to explain coercive control, to explain what its components are. And as I read this case, it has coercive control written all over it. So the better the expert that they hire, the better they're going to do, because you really do have to explain to judges and Americans that there is a controlling force that can be psychological, that can harm people, and that they can't walk away from until they're brought out, until they're deprogrammed. So it will be a battle of the experts, I'm sure.
Shanti Norris is on the record many years ago stating that all of her interactions with Swami Satchidananda were consensual and loving. And you and I both know that this is extremely common for victims of grooming and sexual violence to say something like this. And it often takes years for a survivor to unpack what happened to them. But Yogaville is still using this as part of their defense. I'm wondering, how is this generally understood in civil litigation if someone says they didn't fight back or they froze, or earlier statements say that they loved the leader?
Right. And this is another element where a psychiatrist or a psychologist will have to write a report and explain that survivors who are not yet free or are fearful will frequently say, oh, yeah, I was involved. And also, to some degree, psychologically, they may believe that, oh, this was really my fault. They blame themselves and they feel guilty that they let this happen. But in fact, they didn't have the capacity not to let it happen. And so that's another element of these cases that needs to be explained to the judge or the jury from an expert perspective. But the science is solid. It's very, very common for someone who is in one of these cases, a survivor, to make that kind of statement earlier in their lives and now say, no, now I'm ready for real justice.
Yeah, there's that self-blame element you mentioned, but also in the case of Yogaville, there's the group pressure to normalize that thought, because if anyone speaks out about anything like this, the response, and even I've seen this in Facebook comments about this case, is, oh, well, this is their karma that they brought on themselves. So it was really a spiritual lesson that happened. And if anything happened that was bad that you didn't like, it was probably your fault.
Yes, so that is such a typical religious context statement. They'll turn the religious doctrine against the victim to keep the victim silent. It's sad.
In this post-Me Too era, it's generally understood that consent is never possible if there's such a huge power imbalance, like if one person is an international spiritual celebrity who is deified by hundreds of thousands of people, and the sexual partner being a teenage volunteer. But how are the courts going to look at this? What is the definition of consent in New York, where this case is taking place?
Well, first of all, a teenager is a child. Children can't consent. But secondly, if they're 18, 19, right, if they're older teens, then consent is a question of fact. And in these cases, with the kind of experts we're talking about, it's not consent. The fact that the sex occurred with this huge power differential and his huge reputation against their youth and vulnerability, they couldn't have consented adequately in order to protect him from a claim of rape.
Yeah, one of the guests that we interviewed on this show, her parents, when she was 17, allowed the Integral Yoga Institute to take care of her. And Swami Satchidananda groomed her. But for everyone that I've seen so far, he waited until after they were 18 to do this to them. Are there any laws against grooming?
That is a really good question. It is a slowly growing movement across the United States. There are now, well, it's less, but almost a handful of states that have explicit grooming laws. There should be more, because the grooming is integral to the abuse. It creates the opportunity for the abuse. The fact that he's waiting is he's avoiding the statutory rape argument. Often our criminals know the law better than anybody else to protect themselves. And so I can see why he would do that. But when you're dealing with coercive control, age is not the central question. The question is the coercion. and the level of control. And so in this case, I think starting early and grooming them before there's the full sexual contact actually in some ways is a testimony to his own bad conscience, which should help.
And how is the court going to evaluate claims that an institution like Yogaville created the conditions of abuse, even if no one alive physically committed the abuse themselves?
Well, it's not whether they committed the abuse, it's whether they knew abuse was happening or should have known. In a lot of cases, the question is, were they aware that their employee, the Swami, was alone with children and with young women who were far more vulnerable than he was? Are they aware of traveling together with him? Are they aware of the fact that some of the victims maybe they don't know they're victims per se, but they know that they're struggling, that they're suffering in some way? All of that in this day and age should tell them something. Now, these crimes, as I remember, occurred in the 70s.
Yeah, the late 60s throughout the 70s.
Yeah. Still, the employers were still held to a standard of having to be watchful over their employees, not to harm anyone else in the organization. And so if whatever hints were out there, they should have been putting together. And their instinctive trust of a leader and ignoring the well-being of the girls, whether they were volunteers, employees, or something in between, that's their responsibility.
It's so interesting talking to outsiders about this because just hearing you call Swami Satchidananda an employee just really shifts things for me. And it's reminding me of some literature I read about charisma, where people say that charisma is transferred from the person admiring to the charismatic authority. So it's all these people are giving him power, and they really should have been checking him when he was doing all this,
Right.
and they knew about it.
Precisely. It is one-on-one comparison with a priest.
Mm-hmm.
Right? It is the priests in the 60s and the 70s that were preying on children were treated as though they were in fact God. And that institutional set of assumptions was what made it so easy for them to abuse so many children. And this is the same scenario. So the organization has clothed a human with unaccountability. And by doing that, they've created their own liability.
Yogaville is arguing that all of the conversations, actions, and interactions with Swami Satchidananda should be barred because of something called the dead man's statute. Can you explain what this is?
I'll be honest with you, I don't know.
Okay.
Yeah. I mean, I assume that statements of deceased predator
Mm-hmm.
cannot be introduced because he can't respond to them, because he can't challenge them. So, sorry.
I mean, but that's saying something, that you're such an authority in this field and you've never interacted with something called a dead man's statute,
No.
but that's one of their main defenses. So that's interesting to know.
That is funny, isn't it? It is the first time I've heard of the dead man statute, and I've talked to thousands in the last 20 years. So yeah, no, that's a really interesting point.
In this case, Yogaville responded to the litigation against them by making counterclaims stating interference with business relations. What do you make of that? Is that something that commonly happens if an organization is sued for sexual violence, or is there usually a counterclaim?
So this is very unusual, but it was pioneered by a really disgusting perpetrator, Rick Butler, a volleyball coach in Chicago. And he was sued, or he was identified by one of his victims and by others in the elite volleyball community. And he sued them on these very business theories. And it has been a nightmare for them. And I really do believe the states need to block these kinds of theories in these cases. I also believe With respect to defamation claims, which I understand they were also raised, if an alleged perpetrator wants to sue the victim, the alleged victim at the time, for defamation and they lose on the facts, I think they should have to pay treble damages. In other words, triple the damage of what they would otherwise owe, because it's too easy. We've had priests all over the country do this. We've had Nick Carter do it from the Backstreet Boys. And it is one of the insidious legal tools that are in the possible weapons for perpetrators. And they need to be scaled back. It's just, it's very, very tragic that that's what would be leveled against them. And here's the other problem with these theories is that you have to pay the lawyer. So those are not theories where you have a contingency fee agreement, which is a personal injury lawsuit. These are theories where a victim might end up having to pay $100,000, $200,000 to cover the cost of being defended against these claims. And so I see in this case that the court agreed to give attorney's fees, said that the bad guys had to give attorney's fees to the plaintiffs. That's exactly where it should have landed. But honestly, if the laws were better, those kinds of claims would have been stopped in their tracks.
Yeah, I completely agree. So in this Yogaville case, like I said, they made those counterclaims for defamation and interference with business relations. The court struck them down. But then Yogaville came back and said, basically, we don't agree with that decision, and asked for another court to look at this. They were shot down again, but I mean, you said it wasn't too common for them to do it one time, but this is twice they said they disagreed with the court's decision. What do you make of that?
I think that this group has hired some attack dog lawyers, and they're following their lawyers' advice. And, honestly, I don't have a whole lot of respect. I have a lot of respect for the legal system and the need for lawyers for both sides. But the defense lawyers who make it their business to trivialize and go after victims really are some of the lowest of the lows.
The interesting thing about this case is Yogaville's attorney is on the Integral Yoga Board, and I'm assuming is still a devotee. So they have someone who's devoted to Swami Satchidananda defending them. And
that's unfortunate.
Mm-hmm.
That's very unfortunate, because you combine the irrational attachment to the group and the mission. And typically in religious organizations, there's a shared mission to protect the organization at all costs, because in religion, the end always justifies the means. And if that's who's representing them, then I can see how this would be particularly ferocious and cruel.
Mm-hmm. It's disappointing that that's happening, but I almost feel like it's going to work out in the women's favor, because he has these blind spots, and also the attorneys that are working with these women are incredible. What do you think people should understand about the difference between spiritual authority and legal authority?
So it's funny, in one of the first Catholic bankruptcies that I was brought in on as a First Amendment expert, not an expert, but one of the litigators, but I was doing the First Amendment claims. The Catholic bishops were arguing that federal bankruptcy law is controlled by canon law, literally telling a federal judge that the law she should apply is canon law, and that they could not be governed by anything that was secular law. And the judge in the end looked at them and said, you know what? I am a civil law judge, and I'm going to apply federal law. I'm not controlled by canon law. And that was exactly our argument. And, those arguments have had to be made in a number of cases. But the key is the judge needs to understand that the First Amendment does not permit the judge to determine religious beliefs or apply religious beliefs. The judge is just supposed to look at the secular civil law and apply it to the facts. And the fact you've got a religious actor is utterly irrelevant. Did they do the elements of either the crime or the tort? If they did, the fact they're religious does not defend them.
With all your experience, what do you think the most likely outcome for this case is going to be?
Well, the vast majority of these cases will settle right before trial. The vast majority. And it makes sense for the following reason, is that the day before trial is when all sides are ready better than they've ever been. They've really worked themselves to get to this deadline. They know the strengths and weaknesses of their case. And it is the perfect moment to say, okay, let's sit down. For the survivors in a case like this, a trial can be extremely re-traumatizing. And so it can be very attractive to have gotten all the facts that they've gotten through discovery, but then not to have to go to trial. For the religious group, a trial is a public event. It will put them in a bad light. The mere existence of the trial will put them in a bad light. So it's not attractive for that side either. So we'll see. But the arguments, I believe, are strong enough where these women should be able to get at least to the day before trial. And then if it's not satisfactory, what's being offered or what the deal would be, because, most survivors want two things from the beginning. They want this to never happen to another person. They don't want another girl to be sucked into this horrible universe. And they need compensation, which is the American system. That's what we do. If you're harmed, you get compensation. There may be discussions about better prevention, about understanding, about knowledge, or it will just be a monetary settlement. And there will be a back and forth about that. But they have strong claims, and we've seen this before. And this is not new territory for judges.
I'm wondering, since there's this aspect about Yogaville, the legal fees that they were charged for after this bogus counterclaim they made, the plaintiff's legal fees, they're saying it was over like $150,000 to do all this stuff. But Yogaville is saying we should pay $10,000 maximum. Would that affect a settlement if they don't have enough money to settle in a way that's going to be appealing to the survivors?
Well, there are going to be a couple of questions. One is, did they have insurance? Do they have insurance? Because insurance typically should pay at least 50%. Two, do they have property? Do they have things other than liquid funds? I mean, they always come forth and say we don't have enough or we can't afford, et cetera, et cetera. But in the discussions, there will be discussions about exactly all of their holdings. Now, say they only have $150,000 and they pay that $150,000 in attorney's fees, then there'll have to be discussions between the lawyers and their clients. And, there's a lot that can be done, and I'm sure these lawyers have good intentions. So we'll see.
All right, Professor Hamilton, thank you so much for explaining all that to us. I learned so much, and I hope all the listeners did too.
Thank you so much for having me and bringing to my attention this fascinating case. I really am rooting for them and hope they can overcome yet another religious group that is putting people at risk.
I'm sure they'll be happy to hear your support. Like I mentioned in the beginning of this episode, the Yogaville lawsuit was settled on June 20th, 2026. The joint settlement between Susan, Shanti, Yogaville, and Integral Yoga reads as follows. Quote, "The parties acknowledge that sexual activities took place between teacher and student. The parties acknowledge that those activities were inappropriate, but did not involve physical force or physical coercion. The parties acknowledge that organizations did not know about the plaintiff's sexual experiences during their time as devotees. Swami Satchidananda is a source of spiritual teaching and inspiration for many within the organizations. This joint statement shall not be presented, posted, or disseminated in any way other than its entirety." End quote. Now, before I give you my opinion about this statement, I want to say that I genuinely hope that Shanti and Susan are satisfied with this outcome. Court cases that involve sexual violence are grueling. This process has involved 4 years of back and forth litigation where Shanti and Susan not only had to reopen their very traumatic experiences to the public, they were also subjected to vicious attacks in the form of counterclaims from Yogaville and online harassment from the integral yoga community. Given all of that, I understand why they chose to settle. This outcome is exactly what our legal expert guest predicted would happen. So my criticism is not directed at the plaintiffs. I respect their decision. All of the anger that I feel is never going to be directed towards any victim of Swami Satchidananda or Yogaville. All of my anger is directed towards the current Yogaville leadership and everyone who continues to support them in their horrible decisions. That being said, the first line of that statement calls what happened sexual activities. The first thing I thought when I read that was, okay, I guess we're calling rape an activity now. The second thing that came to my mind was the famous Malcolm X quote.
You feel, however, that we're making progress in this country and worldwide?
No. I will never say that progress is being made. If you stick a knife in my back 9 inches and pull it out 6 inches, there's no progress. You pull it all the way out, that's not progress. The progress is healing the wound that the blow made. And they haven't even begun to pull a knife out, much less try and heal the wound. They won't even admit the knife is there.
Yogaville has barely begun to acknowledge the knife. That's because in order to fully acknowledge that knife, they would need to say in explicit terms that Swami Satchidananda took advantage of and raped some of his devotees. Language is very important, so grooming and coercive control should never be referred to as an activity. I think framing what happened as a sexual activity is harmful for women who are vulnerable to this type of abuse. The joint statement also claims that the organizations had no knowledge of the plaintiff's experiences at the time. I think that's bullshit because even if that technically is true for these two individuals in this case, this does not address the broader pattern that has been described by multiple former devotees. According to many accounts, including those shared on this show, these relationships were widely known or at least strongly suspected within the community. It's important to remember that this statement only refers to Susan and Shanti, the plaintiffs in this case. It does not account for other known allegations of guru abuse within these organizations. It does not address the larger pattern of organizational negligence. Virtually everyone that we have spoken to on this show acknowledges that the predatory relationships Swami Satchidananda had with his teenage students were an open secret. The joint statement does not reference the other 8 victims of Swami Satchidananda that we know of. According to the testimonies of both plaintiffs, Susan and Shanti did not notify the organization of the nature of their relationship with their guru until decades later. There was a major rupture in 1971 when Sylvia Shapiro went public with her allegations. That alone should have triggered a serious investigation into the scope of what was happening. Instead, Yogaville and Integral Yoga continued without fully confronting it, and more people were harmed. Also, while Susan and Shanti's testimonies do not say that they were subject to physical force, Swami Satchidananda did physically force himself onto Sharada Thompson, who spoke about that experience on this show. Listen to episode 6, where Sharada talks about this. Listen to episode 7, where Vijay, who was an Integral Yoga leader at the time, mentions a community meeting about the sex scandals with Swami Satchidananda that happened in the 1970s. Listen to episode 8 of this show, where Maxim, who was sexually assaulted by a devotee in Integral Yoga, says he was shut down by Swami Satchidananda when he told his guru about this. Maxim also said that he saw Swami Satchidananda stick his tongue down a young woman's throat at satsang in front of everyone. He said that this young woman was new to Integral Yoga, and she looked uncomfortable after that happened, and he never saw her again. Alongside the settlement, Yogaville released a letter addressed to the community. In that letter, Yogaville leaders like Jiva Abate and board member Wayne Wilansky state, quote, "We want to acknowledge the courage it took for Sharon, Shanti, Norris, and Susan Cohen to come forward. We recognize the pain and difficulty they endured throughout this process." But that sentence stands in sharp contrast to the legal strategy we've watched unfold over the past 4 years. The reality is that Yogaville's legal strategy involved aggressively fighting Susan and Shanti in court, accusing them of defamation and attempting to discredit their claims. Those two things do not align. They are using passive language to describe how these women felt throughout this process without acknowledging that they are part of the reason why they have gone through so much pain and suffering. Literally last month, Yogaville was filing paperwork attacking these women, so I do not believe that they have had a change of heart that quickly. I think I'm actually going to do another episode that goes deeper into the details of how cruel and nasty the Yogaville swamis and lawyers have been throughout this entire process, because it's so bad, and we really haven't even touched on how horribly these people who call themselves leaders have conducted themselves. Another sentence in the letter in regards to how Yogaville completely abandoned the integral yoga community throughout this process states, quote, "We recognize that the lack of timely and ongoing communication may have left many of you feeling unsupported. For this, we are sincerely sorry," end quote. That sentence definitely triggered me because one of my biggest pet peeves is a sorry you feel that way ass apology. If you're going to apologize, do it right or don't do it at all. So many victims of sexual violence who have ever wondered, what will happen if I come forward, have now watched 4 years of litigation where 2 women were publicly attacked, accused of lying, and forced to defend themselves over and over and over again. This is why I believe that Yogaville is not safe and it is harmful to women. If Yogaville wants to apologize to the community, they need to apologize for calling all of us who supported Swami Satchidananda's victims online as a conspiratorial cabal. That's not an exaggeration of words that I'm using. This is a direct quote from the lawsuit itself. Quote, "The plaintiffs herein have been very careful to not repeat the allegations outside of the 4 walls of the instant litigation. However, they have communicated to others and have conspired, colluded, and created a cabal of friends and family that have repeated the allegations contained within their summons and complaint in public settings with the express purpose of monetarily damaging the organizations sued herein. To that end, they have infiltrated the organizations through an organization called the Yogaville Community Association and through Facebook pages, including Sangha Soundboard and other websites. Additionally, Plaintiff Norris has recently gone on public radio to discuss the lawsuit and claim sexual abuse, where none took place. So if you ever posted in a Yogaville community Facebook group and supported Susan and Shanti online, Yogaville leadership called you a cabal not very long ago, and they didn't mention that in their sad excuse for an apology that they just released. When all of this first came to light, members of the Yogaville community cultivated online healing circles so people could process this. When I spoke at one of these meetings, Swami Premananda, who wrote a very disturbing statement in this case, sent me vicious messages on Zoom about how I don't know what I'm talking about. Yogaville, if you want to apologize, you need to apologize for attacking all of us who were just trying to heal and have our voices heard throughout this entire process. While I am very angry about Yogaville's response to the joint statement, I still feel like a lot of good has come out of this. For one, the public now has information it didn't have before. The public record has changed. It is no longer credible to deny that Swami Satchidananda had sexual relationships with his students who were significantly younger than him and under his spiritual authority. Second, this case has helped clarify a broader pattern: negligence. Not just in this instance, in this case, but across multiple situations connected to this community. Failures to act, failures to investigate, and failures to protect spiritual seekers who came to Yogaville. From Swami Satchidananda's sexual abuse of young women, to Doc Antle and the Tiger King scandal, to the many children who have come forward about being abused at the Yogaville school, the framework of negligence makes so much sense to me and has helped me understand my experience at Yogaville so much more. This pattern of negligence can also be seen in a story about Swami Karunananda, who is currently serving on multiple Yogaville boards. Many years ago, she was sent an email from a man who expressed plans to murder an integral yoga teacher. According to accounts that have been made public, she didn't notify law enforcement or warn the community. If Swami Karunananda did not neglect to act in this situation, that person may still be alive today. And this isn't a rumor. There are newspaper articles about this that you can read on culteducation.com. Again, Swami Karunananda is on multiple Yogaville boards. Wayne Wolanski, the evil, slimy lawyer, is still on the Integral Yoga New York board. These are the people who are making decisions in the Integral Yoga community. When you donate money to Yogaville, this is what you are supporting. This conversation isn't over just because this lawsuit ended. If anything, it's just beginning. More people now know about Swami Satchidananda's abuse of his students. More survivors have been heard. More questions are being asked about institutional accountability, spiritual authority, and how communities respond when allegations of abuse surface. And regardless of what we think of the settlement itself, I think that's a meaningful outcome. Once again, I'm Brianna Patton. Thanks for listening to Surviving Satchidananda.